Hi everyone, welcome back to The Whole Truth. I'm Gillar Bell, your attorney at law, and I decided to do a live last second because I just downloaded the reply brief in the Tyler Robinson case, and I have not read it yet, and I wanted to read it because I have a few guest spots tomorrow, and so I was going to read it anyways, and I figured why not read it on live, share my initial reactions with everybody. So I know that other people are live right now. I don't expect anyone to stop everything they're doing to join me, but I'm going to get started. Now, before getting started here, and I actually have to probably keep my voice down a little bit because my baby's sleeping in the next room. I'm not expecting anything earth shattering in this reply brief. Remember what I said before? It's really only designed to address the points that the defense brought up in their brief. So we're not going to really see any new evidence discussed or anything like that. But should make for some interesting discussion. And while I'm here, let me share real quickly on X. I also realize that it's late. It's late where I am. It's 11 on the Pacific coast. So I am certain that a lot of my usual watchers are sleeping, because I know a lot of you are on the East Coast. But I wanted to get started. Okay, so this is the reply memorandum in support of the preliminary hearing. And I will try to read it as much as possible, but I am going to skip over any kind of boilerplate stuff because otherwise it would probably take a while. Introduction. Defendant does not challenge the substance of the evidence demonstrating that he was the person who crawled to the sniper's perch on the Lucy building rooftop, fired the fatal shot that killed Mr. Charlie Kirk, hid the rifle in a wooded area, got rid of some of the clothing he was wearing, and told his roommate to delete their texts about the shooting. Rather, he merely asserts the repeatedly rejected claim that the overwhelming evidence establishing some of these facts could not be introduced as reliable hearsay at this preliminary hearing. Defendant therefore raises no valid challenge to the evidence supporting count 1 as at least murder, count 2 felony discharge of a firearm causing serious bodily injury. That's true. They did not do anything about count 2. Counts 3 and 4 obstruction of justice. That's true. They did not. The defense did not address those counts, or count 5, tampering with the witness. So that's all true. Counts 1 through 5, basically the substance of the counts were not addressed by the defense. Defendant's challenge to the aggravating circumstance for count 1, that he knowingly created a great risk of death to another, is based on his misrepresentation of both the evidentiary standard at a preliminary hearing and the test for establishing the aggravating circumstance. And by his, this is referring generally to the defense. As for the evidentiary standard, defendant erroneously asserts that a magistrate engages in speculation when he chooses between a reasonable inference that supports guilt and a competing innocent inference. The Utah Supreme Court has rejected that logic, a fact the Utah Court of Appeals has repeatedly recognized. Defendants' counsel ignore this controlling case law and have therefore violated their ethical duty of candor to the court. Oh, that's quite a strong charge to accuse opposing counsel of violating an ethical duty of candor. Contrary to the defendant's argument, these cases establish that when a fact finder chooses between reasonable inferences at a trial, it is properly fulfilling its fact-finding role, not speculating. Thus, even at a trial, a fact finder is free to choose between reasonable inferences. This is a preliminary hearing where this court does not sit as a fact finder. Instead, this court is duty-bound to draw all reasonable inferences in the state's favor. It is therefore even more apparent that in this proceeding there is nothing speculative about viewing all reasonable inferences in the state's favor. As for the great risk of death aggravating factor, defendant erroneously maintains that the test for establishing this factor depends on the presence of some minimum number of factors or circumstances. In fact, the Utah Supreme Court has expressly disavowed such an analysis. Instead, the governing test is the one the statute provides, whether a defendant knowingly created a great risk of death to another. The evidence here easily establishes at least probable cause to believe that defendant did so when he intentionally fired his grandfather's high-powered rifle towards a crowd of thousands, several of whom were in the line of fire between him and Mr. Kirk, while others were in close proximity to Mr. Kirk. Indeed, the evidence is more than sufficient to support a finding beyond a reasonable doubt. So I was just saying it's much stronger than just probable cause. Now, it's common for both sides to argue as vociferously as possible. Doesn't mean that what they're saying is true or what the defense was saying is true. Keep in mind that they're just making their best arguments. So it's often the case that both sides go much further than what the evidence shows or what reasonable inferences might lead to in order to kind of set the goal overly far and have the judge meet somewhere closer to where you actually want them. Defendant's challenges to count 6, witness tampering for directing Mr. Twiggs not to talk to police, and this is the one that I'm going to stick by my prediction, but I could be wrong, is the one that they're going to be successful on, the defense. And number 7, in getting dismissed. And number 7, violent offense in a child's presence, likewise improperly draw inferences in defendant's favor, not the state's, while also ignoring relevant evidence. Defendant's challenge to the victim targeting enhancement on count 7 similarly ignores the evidence. Finally, defendant also misrepresents the holding in Apprendi v. New Jersey in arguing that the sentencing enhancements for committing a violent offense in a child's presence and targeting his victim must be proven now. Neither enhancement implicates Apprendi because neither increases the maximum statutorily mandated punishment. And this is kind of what I was saying. It's unclear if the sentencing enhancements need to be shown even by probable cause standard at this stage. So let's see what the argument is. Let's get right into it. Argument. Number 1. Defendant misrepresents the governing evidentiary standard because he relies on an erroneous distinction between inferences and speculation that the Utah Supreme Court has rejected. Defendant misrepresents the evidentiary standard that governs this preliminary hearing because he relies on an erroneous distinction between inferences and speculation from State v. Cristobal that the Utah Supreme Court soundly rejected over a decade ago in State v. Ashcraft. The Supreme Court explained in Ashcraft that when a jury chooses between reasonable inferences to reach its verdict, it does not engage in speculation. This is even more true at a preliminary hearing where the magistrate must draw all reasonable inferences in the state's favor. So basically, this is saying that the defense's brief was saying that the court cannot rely on speculation, whereas the state is saying that this is not speculation, these are reasonable inferences, and the court is obligated to make reasonable inferences in the state's favor at this stage of the preliminary hearing stage. Because he ignores the case law that rejects the logic on which his argument depends, defendant erroneously labels as speculation many of the state's arguments about the evidence and the reasonable inferences this court must draw from the evidence. And then it cites to the defendant's memorandum. For example, although the evidence demonstrates 1, that a clear line of sight existed between defendant's sniper perch and Mr. Kirk's seat, and 2, that others were near Mr. Kirk when defendant fired the fatal shot, defendant asserts that this court would be engaging in, quote, speculation to infer from this evidence that defendant, quote, actually observed security personnel or others standing near or directly between him and Mr. Kirk. Similarly, although the evidence shows that defendant loaded his rifle with 4 cartridges and had previously done some target practice where he seldom hit the bullseye and sometimes missed the target completely, defendant asserts that it would be speculative to infer that he knew he could miss the target, his target. Defendant relies on State v. Cristobal to justify his argument. Quoting Cristobal, defendant asserts that when evidence supports more than one possible conclusion, none more likely than the other, the choice of one possibility over another can be no more than speculation. So this is what the definition of speculation is, where there's many possibilities and none are any more likely than the other. But the Utah Supreme Court rejected Cristobal's logic in Ashcraft, a fact the Utah Court of Appeals has expressly and repeatedly recognized. These cases make clear that choosing between competing reasonable inferences is not speculation, but rather exactly what a jury must do. So they're just using these cases, even though they involve juries, to basically define the difference between inferences and speculation. Inferences being allowed by the court at this stage, and speculation not. The defendant in Ashcraft argued that the existence of innocent inferences for his presence in a known drug area late at night with a large amount of cash rendered the evidence insufficient to support a jury verdict that he constructively possessed drugs. Consistent with the Court of Appeals' reasoning in Cristobal, Ashcraft asserted that his jury engaged in speculation. Whoa, hold on one second. I'm going to restart.